A well-regulated militia be necessary to the security of a free state? The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad to have you with us on the program today. And I got to rant just a little bit here. I don't normally do this, but, every morning I wake up, actually every night before I go to bed, I check the Googles and the internets for the latest Second Amendment news and information. Do it again in the morning. And I saw a couple of headlines today that really took me back. I thought for a second maybe I had missed a big development in terms of the world of the Second Amendment, the Supreme Court taking a Second Amendment case. Look at these headlines here. This is from the Daily Caller. Justice Barrett's vote already looking to be decisive in first big gun rights case in years. And then you've got, let's see, this is Vanity Fair. Amy Coney Barrett already tipping the scales in crucial SCOTUS cases. And I'm thinking to myself, okay, did I miss something? I mean, I'm pretty good about following what's going on in the Supreme Court in terms of our Second Amendment rights. And the answer is no, I did not miss anything. What these headlines are talking about is a case that the Supreme Court has not yet agreed to take. In fact, the Supreme Court has not even officially been asked to hear this case. But the confusion comes, and this is really sort of the two-way game of telephone. You know that old game where you sort of, somebody whispers in your ear, right? And then you're supposed to whisper the same thing to another person. And you go down the lane, and then you finally figure it out. You go through 12, 14 people, and you ask that last person, okay, what did you hear? And they say something like, you got to go pick up dog food at the grocery store. And the first person actually said, boy, I could really use a beer right now. Right. As each person changes their story or hears that whisper and they change things just a little bit, all of a sudden now you've got an entirely new story. So I tracked this back to a piece at the New York Times. Justice Barrett's vote could tilt the Supreme Court on gun rights. For years, they write, conservative justices have said that the court disfavors the Second Amendment. Justice Amy Coney Barrett is likely to shift the balance, and a case to help her do so may be knocking. All right, maybe knocking. This is a case called Fulcher. I'm probably going to butcher the name. We've talked about it on this program before. Lisa Folger was convicted of tax evasion back in 2011. She would like to have her Second Amendment rights restored. She's been unable to do so. The Third Circuit recently ruled against Lisa Folger. And that means that the next stop for this case would be the Supreme Court. Fulcher's attorneys can ask the Supreme Court to hear this case, to grant cert, is the legal terminology, but they've not yet done so. And it doesn't really matter, apparently, to a lot of media outlets who have puffed up this case, I think largely based on a post by Jonathan Turley. And this was last week. I remember talking with Ed Morrissey about this during our VIP Gold live chat last Wednesday before Thanksgiving, because Ed had written a piece about this. And the reason why I think the media is fixated on this case is because you remember back during Amy Coney Barrett's confirmation hearings, one of the cases that she brought up specifically when she was asked about cases that she's been involved in that, she was most proud of decisions or opinions that she had issued. And she talked about a case called Cantor versus Barr. This, too, dealt with an individual who was prohibited by law from possessing a firearm, a guy named Ricky Cantor, who lost his Second Amendment rights when he was convicted of one count of mail fraud. Basically, he was selling shoe inserts that he said were Medicaid compliant, and they weren't. And Ricky Cantor was sentenced to a year and a day in federal prison, and as a result, suffered a lifetime deprivation of his right to keep and bear arms. Ricky Cantor had sued, trying to get his rights back, and when Amy Coney Barrett was on the 11th Circuit Court of Appeals, she was part of a 3-judge panel that heard this case. 2 of the judges said, sorry, Ricky, you're out of luck. Federal law is clear. You are a convicted felon. Therefore, you're barred from possessing firearms for the rest of your life. Amy Coney Barrett said, well, hang on one second. Not quite so fast. Because if you look at the history and the tradition of the right to keep and bear arms, it's pretty clear that the founders did not intend for a felony conviction to be the standard by which individuals lost their right to keep and bear arms. Instead, she writes that the standard was dangerousness, and that a simple felony conviction, particularly those for a nonviolent crime, does not automatically mean that somebody is dangerous. And so she would have afforded Ricky Cantor the opportunity to regain his right to keep and bear arms. Well, the Supreme Court decided not to hear that case. And there are a lot of similarities to the case of Ricky Cantor and Lisa Fulchar. That's fine. I mean, we can point this out and we can say, look, this is a case that Amy Coney Barrett might be really inclined to address. But that's kind of putting the cart before the horse when you say that, the Supreme Court is likely to take this case, or this is the case that's the next big gun rights case. It's not. In fact, this is not even the next felon in possession case that's going to come before the court. And what drives me crazy here is you've got folks who don't understand. It's not. Let me backtrack a little bit. Some of these reporters may understand the Second Amendment, but they don't cover the Second Amendment on a daily basis. This is not their beat. And so they know what they know, but they don't know what they don't know. And what they know is that Jonathan Turley wrote about this case last week, because now everybody's writing about the Fulcher case. What they don't know is that the Supreme Court on December 11th is scheduled to hear in conference a case dealing with the loss of the right to keep and bear arms. This is a case called Torres versus the United States. And they're going to hear this before Fulchar is even heard in conference. The Supreme Court is going to get a chance to weigh in as to whether or not they're going to accept the Torres case. Now, here are the facts in the Torres case. Israel Torres is a husband, father of three. In 2017, he kept a number of firearms in his home where they were available for defense of himself and his family, according to his attorneys. But on February 16th of 2017, federal law enforcement agents entered Israel Torres' home, forcibly removed his firearms, and arrested him for having them. The lawsuit filed by Israel Torres says that the justification that the agents used for disarming Mr. Torres was that 12 and 6 years earlier, he had been convicted of driving under the influence offenses. In 2004, he was convicted of aggravated DUI with a person under the age of 15 in the vehicle, which was a Class 6 undesignated felony under Arizona law. He was sentenced to 1 day in jail, 18 months probation, 9 days suspended. A decade ago, in 2010, Torres was convicted of aggravated driving or actual physical control of a vehicle while under the influence of intoxicating liquor or drugs, which is a Class 4 felony under Arizona law, for which he was sentenced to 8 months of imprisonment, followed by 3 years of probation. In light of these convictions, the attorneys say the government charged Mr. Torres with 2 counts, including 2 different sets of firearms and dates of possession, of violating U.S. Code Section 18, 922G1, which provides that, quote, it shall be unlawful for any person who's been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year to possess a firearm. So Mr. Torres filed suit originally in U.S. District Court, arguing that this section of law, as applied to him, violated his Second Amendment rights. And he has acknowledged that the Heller decision described, quote, longstanding prohibitions on the possession of firearms by felons as presumptively lawful. But his attorneys also argue that many circuit courts have found that the presumption is rebuttable in individual cases and have entertained as applied Second Amendment challenges to this section of federal law. In fact, they say that one circuit court has found merit and granted relief in 2 such challenges, a case called Binderup versus Attorney General from the Third Circuit in 2016. Mr. Torres further acknowledged that the Court of Appeals opinion in a case called U.S. versus Vongske could also be read to preclude as applied Second Amendment challenges to this section of the law, but he argued that that case did not actually settle the issue and that if it did, it was wrongly decided. He also argued that his as-applied Second Amendment challenge has merit because his felonies were nonviolent and would not have historically resulted in the loss of his right to keep and bear arms. Again, the same argument that Ricky Cantor is using, or used, and the same argument that the attorneys for Lisa Fulchar is arguing as well. And again, this case is going to be heard in conference. It's already reached the Supreme Court. The Supreme Court hasn't granted cert in this case, but they're going to hear this case long before they hear the case of Lisa Fulcher. And yet, neither the New York Times story, the Vanity Fair story, the Daily Caller story, I don't even think the Jonathan Turley piece even mentioned the Torres case. So I'm annoyed a little bit this morning because you've got all of these media outlets reporting breathlessly, this is the case that Amy Coney Barrett could take. I mean, it could be. Look, it could be. But there are other cases dealing with that exact same issue that have already reached the court that nobody's talking about because they don't know what they don't know. I'll even go further because I think that the court has the opportunity. This case is going to be heard, as I said, in conference on December 11th of this year. So it's coming up in just a couple of weeks. There is another case called Hobbs versus the United States that has not been distributed for an upcoming conference, but it's at that level. So it could be going in just a couple of weeks. So there are actually a couple of cases dealing with the deprivation of rights for those convicted of a felony that will get to the Supreme Court long before Fulcher. But even then, there's another question. You know, the writing regarding the Fulcher case has typically, the narrative has gone something like this. Amy Coney Barrett thinks that felons should be able to regain their rights. Here's a case in which a felon's asking to regain his rights. Holy cow, this could be the next big case that the Supreme Court takes. Well, it's not only up to Amy Coney Barrett, right? It takes 4 justices to agree to hear a case in conference. Obviously, it takes 5 justices in order to get a majority opinion. So we know that Amy Coney Barrett, I think it's fair to assume that Amy Coney Barrett is interested in these types of cases and may very well vote to accept one of these cases, including the Torres case when it comes up in just a couple of weeks. Brett Kavanaugh has also expressed an interest while he was an appellate court judge in issues like this. So you got, I think it's fair to say that you likely have 2 votes to hear one of these cases. But do you have 4? Do you have Justice Alito? Do you have Justice Thomas? Do you have Justice Roberts? I don't think you have Justice Roberts. And I'm not sure that Justice Thomas or Justice Alito are going to want to pick this particular case or a case dealing with the loss of rights by convicted felons as the next Second Amendment challenge. And I think that a lot of this writing that we've seen here regarding the Fulcher case or the next big gun rights case that the Supreme Court's going to take, I think it's really putting the cart before the horse. You know, the Fulcher case came out of the Third Circuit Court of Appeals, and I wrote about this, I guess it was a few days ago. Just about 4 days ago. Another case out of the Third Circuit. New Jersey's magazine ban challenged in the Third Circuit Court of Appeals. And this case was recently denied an en banc review by the Third Circuit. So the next stop for that case is going to be asking the Supreme Court to grant cert. So it's quite possible that that case could actually be accepted by the court before the Fulcher case would be accepted. So again, also possible that the Hobbs case dealing with the loss of the right to keep and bear arms would be accepted before the Fulcher case. Now, again, why am I rambling on about this? Because I think it's important that the folks who are covering these issues know a little bit about the issues, that they have some institutional knowledge in these stories and in the issues that they're covering. And you've got, I think, some bad information, some misinformation, and, you know, again, just sort of blowing a story out of proportion while ignoring the other actual cases that could soon be before the court. Hobbs versus United States being one of them, Association of New Jersey Rifle and Pistol Clubs versus Gruwal. That's the magazine ban case. That could be going as well. Why focus on just this one particular case? And that, I think, we have to go back to that original report by the New York Times and the narrative that the New York Times and other anti-gun media outlets are trying to put in place. That, oh my gosh, with Amy Coney Barrett on the bench, you know, get ready, because we're going to see a tidal wave of these Second Amendment cases. I hope they're right, by the way. I really do. I keep my fingers crossed that the Supreme Court is not only going to accept a case dealing with the loss of the right to keep and bear arms, but will again accept a case like Association of New Jersey Rifle and Pistol Clubs dealing with a magazine ban. Out of the Ninth Circuit, you also have a couple of other cases that are worth keeping an eye on. They're not at the same level right now as a Fulcher or Torres or the Association of New Jersey Rifle and Pistol Clubs case, but they're right behind. So you've got a case versus as Young versus Hawaii. We've talked about this on the program before. This is a case dealing with the right to carry in Hawaii, specifically the right to openly carry. In the Ninth Circuit, they have a very tortured reading of the Second Amendment. Going back a few years, there was a case called Peruta versus San Diego, challenging California's May issue concealed carry laws. Edward Peruta was a resident of San Diego, California. He applied for a concealed carry license. The sheriff there said, well, what's your good cause? And Edward Peruta said, well, it's my right to carry. That's self-defense. Nope, not a good enough reason. So Edward Peruta sued, and ultimately a 3-judge panel of the Ninth Circuit said, yeah, Edward Peruta has a right to carry. In fact, law-abiding citizens in California have a right to carry. And these good cause requirements violate their constitutional rights by making it impossible for the average resident of California, or the average resident of San Diego anyway, to obtain a concealed carry license. Now, the state of California appealed that. They asked for an en banc review in the Ninth Circuit. That review was granted. And the en banc review of the Ninth Circuit overturned that 3-judge decision. And the en banc panel said, well, hang on. Actually, no, there's nothing in the Second Amendment that says that you have a right to carry a concealed firearm. So even though California law also bans the open carry of firearms and the average citizen can't get a concealed carry license, we're not going to address the law in totality. We're only going to look at the concealed carry law. We're only going to look at the Constitution. And you know what? Yeah, you've got a right to keep bear arms, but it doesn't say you got a right to bear concealed firearms. So you don't have a right to carry concealed. Boom. End of story. All right. Well, a guy named George Young lives in Hawaii. And he decided, well, okay, if I don't have a right to carry concealed, I must have a right to openly carry, right? I mean, we've got the right to keep, we've got the right to bear. Well, in Hawaii, in order for you to openly carry, you've got to get an open carry license, which has never been granted to a civilian. Sometimes an armed guard might get one, but just average resident can't get one. So George Young applied for his license. He was denied, and he sued. 3-judge panel in the Ninth Circuit said, yeah, Mr. Young has a right to openly carry because, again, the Second Amendment says what it says. You've got the right to keep, you've got the right to bear. And if the Ninth Circuit has said you don't have the right to carry concealed, well, then you must have the right to openly carry. Now, state of Hawaii asked for an en banc review in the Ninth Circuit. That review was granted. Oral arguments were held back in September, and we're waiting on that en banc decision to come down from the Ninth Circuit. It could come down at any time. I think it is likely it'll be sometime in the next couple of months. I would be somewhat surprised if it came down before Christmas. But I think in the new year, I think we're likely to see that en banc decision from the Ninth Circuit in the Young case, a carry case. And once that decision comes down, the chances are pretty good that that case is going to go up to the Supreme Court. If the en banc panel of the Ninth Circuit rules that, no, Mr. Young doesn't have the right to openly carry either, well, then Alan Beck, who's the attorney for George Young, will almost certainly take that case up to the Supreme Court and ask the Supreme Court for review. If, on the other hand, the Ninth Circuit comes back and says, okay, yeah, you've got the right to openly carry, you don't have the right to carry concealed, but you got the right to openly carry, then it's going to get interesting because the state of Hawaii is going to have a decision to make. Do they accept that decision by the Ninth Circuit, which, again, would apply not just in Hawaii, but in California, Oregon, Washington State, Nevada, Arizona? Do they accept that? Which would change the law dramatically, particularly, in a state like California, where open carry is banned for 40 million residents there. Or would they appeal that case up to the Supreme Court, knowing that it was likely that the makeup of this Supreme Court would not rule in Hawaii's favor, would strike down their open carry laws, and would ensure that the right to bear arms actually means something? That's going to be a decision that the state of Hawaii may have to reckon with. But this is another case that could very easily get to the Supreme Court in the next couple of months. So in other words, and in short, it's too simplistic to look at the Fulcher case and proclaim, as the New York Times has proclaimed, that, aha, this is the case that the Supreme Court is likely to take. It's, again, for the reasons I've laid out, I'm not sure that that's the case. The Supreme Court, if it really wants to address the issue of felons in possession, they've got a case before it right now called Torres versus the United States. They could agree to hear. In fact, again, they're going to be hearing this. They're going to be studying this and debating this case in conference starting on December 11th. So I want to point this out, in part because I want you to have the actual facts, but in part because I also want to ding the media for bad reporting on this issue. The issue is much more complex than the simplistic narrative that the New York Times put forth, and that was picked up and repeated by far too many media outlets out there. All right, let's get to today's armed citizen story. Our good deed of the day, our recidivist report as well. We will start there, as a matter of fact, with a case out of Wilmington, North Carolina. I believe this is Wilmington, North Carolina. No, I guess this is Wilmington, Ohio. Yeah. Corey Ruffner, recently convicted in a shooting death, already back out on the streets and already back in trouble, according to authorities. He's scheduled for a probation revocation hearing on December 8th in Clinton County Common Pleas Court, done after discovering that Ruffner had allegedly tested positive for oxycodone and allegedly admitted to ingesting a Percocet tablet for which he had no prescription. Back in September, Ruffner pleaded guilty to one count of involuntary manslaughter in the shooting death of 23-year-old Lane Hall back in January. The judge in that case originally sentenced Ruffner to 2 years of community control, so basically 2 years of probation, ordering that he wear a GPS tracking device. He was also required to follow all house arrest rules, not leave his residence without appropriate supervision or permission, and take part in a community services program for 6 months. During sentencing in October, the judge referenced Ruffner's compliance with the law enforcement investigation as to why he did not receive any jail time. So that was October. And then about a month later, Ruffner again tested positive for illegal drug use. And now apparently, again, there's a probation revocation hearing. But I don't know that he's actually going to get anything other than another slap on the wrist. He was one of 4 suspects charged in relation to Hall's death. 2 others pled guilty to involuntary manslaughter. One of them received a 2-year prison sentence. Another received 3 years of probation. The 4th suspect, 18-year-old Joshua Williams, now faces charges of using a firearm in connection with a crime of violence and drug possession with intent to distribute in federal court. A trial there expected to begin in February of next year. Our armed citizen story of the day from Redlands, California, where a burglar who tunneled into an office. Yeah, I love this story. Burglar who tunneled into an office picked the wrong place to try to break into. Because as it turns out, that office was occupied and the business owner actually was armed. Yeah, according to the Fresno Bee, police responding to a burglar alarm early on Monday morning in Redlands, California at a property management building couldn't find any signs of a break-in. But when the business owner arrived about 5 o'clock in the morning to check things out, he found somebody inside. Turns out the intruder had actually tunneled through a wall from an adjacent office and then rushed the business owner. As the business owner opened the door, the owner opened fire with a handgun, wounding the man. 37-year-old Clemente Wilson Valenzuela suffered a gunshot wound to the chest, the last report in critical condition. Police say they've been investigating a series of recent burglaries in the area. No charges have been filed against the business owner. I know that this is California, but this also would appear to be a pretty clear-cut case of self-defense, so I don't expect that any charges will be filed in that case, although we'll certainly keep an eye open for any updates there. And finally today, our good deed of the day from Branchville, Indiana, where a volunteer firefighter and a corrections officer at the Branchville Correctional Facility is being honored for his life-saving actions. Officer Kyle McGann was visiting with his daughter on the night of October 29th. He was off duty. He's hanging out with his daughter at an apartment when they both heard the sound of a smoke detector coming from a nearby apartment. They tried to get a response from people inside, but there was no answer. And so ultimately, McGann and a officer from the Jasper, Indiana Police Department forced their way inside that residence where they found an unresponsive man lying on a sofa. They were able to get the man out of the apartment. They were able to evacuate other residents in the building as the fire department arrived. And now, Officer McGann, presented with a certificate for bravery, as well as a commissioner's coin by the warden of the Branchville Correctional Facility, Kathy Alvey, as well as the fire chief there in Branchville, Indiana, Jimmy Vincent. So in the right place at the right time, willing and able to do the right thing. Officer McGann, we thank you, sir, for your very good deed. All right, that is going to do it for this edition of Bearing Arms Cam and Company. I want to thank you for being a part of the program. As always, we'll be back tomorrow with more of the latest Second Amendment news and information from all across the nation. I think as well, we're going to be doing another VIP Gold live chat with our friend Ed Morrissey from Hot Air. Again, last week we were actually talking about that Second Amendment case, the Fulcher case. Who knows what Ed has up his sleeve, but it's your opportunity to really, ask any question that's on your mind. Anything that, any upcoming cases or legislation, election leftovers, we are happy to talk about whatever you want to talk about. All you have to do, subscribe, become a VIP Gold member. You can use the promo code LOYALTY, all caps, and get 25% off your membership to Town Hall Media. We certainly do appreciate your support. And we look forward to talking to you tomorrow on the VIP Gold live chat, as well as tomorrow's Bearing Arms Cam and Company. Until we talk again, be well, be safe, be free, and we'll see you soon with another edition of Bearing Arms Cam and Company.